This is the plaintiff, Jack. He says he purchased a building and the defendants were tenants with a pet grooming business. They refuse to pay him the rent they owe. He's tried reasoning with them, has been unsuccessful, and he has no other choice but to sue them for the $1,765 he's owed. These are the defendants, Lori and Brett. Lori says they've been running their pet grooming business in this space for 23 years without any problems until the plaintiff came along. Bottom line, they don't owe this troublemaker any rent as they're fully paid up. End of story. They're accused of going on a rent strike.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case on the docket. The plaintiff says that the defendants are stiffing him over money that he is owed, and he is not going to take it, and that's why he's in the People's Court. But the defendants claim the plaintiff is one of those troublemakers. They don't owe him a cent, and they think the judge is going to agree. It's the case of money grubber.
Thank you, Douglas.
You're welcome.
Okay, Mr. Jack, your business is suing Ms. Lori and Mr. Brett's business, a pet grooming establishment, for rent and late fees. Tell me what's going on.
Yes, ma'am. Good day, Judge. We purchased the property the last day of December 31st of 2020. On or about January the 2nd, I went to the defendant's place of business and left them my personal contact information. And anyway, on January the 5th, I sent the defendants a proposed lease agreement. In that lease, I offered them $9.13 per square foot if they wanted to stay in the property. That is more than $2 less than anyone else there pays. Currently.
It's also how much more than they were. You have a right to do whatever you want. You're the owner, but I'm just asking, how much more was that than they were paying? They were paying $800, and you were asking for how much?
On the lease, it was $1,275 per month.
Okay. Okay. But your original request had been what, $1,500?
That was on a month-to-month basis.
Right.
That would be if they chose not to sign a lease. I called.
You received a call from Brett at some point. When was it that you got a call from Mr. Brett?
On or about January the 8th. And he offered to pay less. On January the 10th, I sent a text message back to him stating that I would accept $1,250 a month for the first year, and then it would go to $1,400 after that. And I did not receive any response whatsoever from them in any way, until almost a month later. I sent on February the 7th. I sent a text message and asked, "What have you decided to do?" They replied the same day that we will be moving March 1st. You can use my security deposit for my last month's rent. I sent back to her and I said, "Ma'am, I do not have a security deposit from you. There was no deposit forwarded to me." She indicated that she had paid a first and a last month's rent. I think if you look at the lease that she signed, she only paid $280 to move in, which $100.
Let me. If I look at the first lease, there's a couple of things I noticed. First of all, Brett's not even a figment of her imagination on this, because this was your business before you met Brett, Ms. Lori?
Yes, it was.
Okay, is it both of your business now, or is it still only your business?
No, it's my business. He just called the man because I was upset about the money.
Okay, I gotcha. So the case against Brett is dismissed, and this is against you, Ms. Lori, and let me talk to you. You've been renting there for how long? 20 years?
Yeah, a little over 20 years, yes, ma'am. And when I first talked to him, yeah, it was. Anyway, when I first talked to this man, when I first talked to him, I told him that we would not be able to give what he was wanting for the place, and that we would have to move. And then he said, "Well, let me know what you come up with." He informed me I would not be able to find anything that would be suitable in the price range I was looking for. And so I did, and I let him know on the beginning of February that we would be moving by March the 1st.
You didn't do that until February 7th, right?
No, I had to find a place first. Yes, ma'am. I had to find
Of
a
course,
place
I
to move to.
I understand. So when you're on a month to month, what kind of notice do you feel you're supposed to be giving your landlord?
I probably should be giving him more of a notice that I was moving, but I also feel like he should have given me more of a notice that he was going to double my rent. I never got anything in writing that he was going to double my rent. He just said in 3 weeks I'm going to owe him $1,500, and I could not do that.
Did
The
you
place is not
ever?
worth.
No, right, I get it. Did the prior landlord let you know that they were selling? Like, did you even have an
No.
inkling that they were selling?
No, ma'am. He came in our business at the beginning of January. I wasn't there, and he started telling all the girls he was the new owner of the building, and we needed to pay him rent and who we needed to make the check out to. And I had no idea who he was. For all I know, he's a scam artist coming around trying to collect money.
All right. So,
and it was a holiday.
Brett, you had a conversation. Brett, you had a conversation with Jack at some point. Tell me about that conversation.
Well, the only thing I could do is my wife was upset because we had two folks that were out with COVID, and one of them lost both their mom and their grandma with COVID that month. And
you mean when you say you had two folks, you're referring to employees?
Yes, it was a girl from the shop.
Yes, ma'am.
Okay, I got it. Okay, go ahead.
All right. Anyway, I talked to him and I said, can you do something? Can you help us out? You know, we could maybe do a couple $100 more a month. And so we're looking at $1,000 at that point. And, you know, he wouldn't do that. And I thought, well, there's just no way we can do that financially. We just can't, we can't double the rent.
Can I say that he offered my husband $25 off? That's what he could do to help us out, was $25 off.
That's what he did.
Here's the thing. I mean, I hear what you're saying. We're in the middle of a pandemic. Business, I'm sure, is a lot slower than it has been. If people are going to cut back on stuff, you know, that might be the place they cut back on a pet grooming service. You've been hit with employees who are sick and having tragedy in their lives. I hear everything you're saying. But what you have to understand is at the end of the day, you don't own the joint. He does. And he can within, you know what I'm saying? So I get that you've been able to be there 20 years with a really low rent, and that's wonderful for you that you were able to do that. But it's neither immoral of him, nor does it make him a bad person that he wants to support his family too. So I get what he's saying, and he has a right to say that. Now, both he and you have to follow what month-to-month law says, because that's the kind of tenancy that you have at that juncture. You don't have a lease at that point, right, Ms. Lori? You're in a month-to-month?
Yes, but not with him.
All right, and you had been, no, and let me explain something to you about that. You're in a month-to-month with whoever owns it. When he legitimately buys the property, he is buying both the assets and the liabilities of the property. That means that if you owe the prior landlord, you owe him. That's how that works. So now, here we are, it's January. He walks in, he attempts to negotiate something with you guys about how you're going to proceed going forward. And he has every right to do that.
No, ma'am, I've never spoke to him.
Okay, so Brett, he attempts to negotiate with you how it is that he's going to proceed, and he has every right to do that. So what ends up happening, because I can see from the text, Lori, you ask her for rent. She tells you she paid it to the last guy. You ask her on January 5th, let me know about the January rent, and then you propose what to do moving forward. And you propose February 1st through July 31st, $1,275. That is the last contact. After January 5th, there are no texts. Oh, there is, no. Yeah, there is. From you to them, you say to them, after much thought and consideration, I'll lease it for the whole year for $1,250. And then I'll give you an option to extend it for $1,400. So everybody's still negotiating. And then nothing between January 10th and February 7th. On February 7th, you ask, what have you decided to do? And she says, we will be moving March 1st. So you clearly did not tell him on February 1st that you would be moving March 1st. Did you, Ms. Laurie?
No, I did tell him, yes, I told him that I would not be able to pay that and that we would have to look elsewhere.
No, that's not the same. Yeah, no. Telling someone, hey, I'm going to move someday is not the same as giving notice. The first time you actually give a date is in
notice.
This text
yes,
on February 7th. Yeah, right.
Yes,
okay.
That's the day I gave him notice, yes.
So that's the notice you gave him, February 7th for March 1st. Now, his response is, I don't have your deposit. The only lease or deposit you had was 3 landlords ago. So you never had another lease after the first lease 20 years ago? You were month to month for 19 years, Ms. Laurie?
Yes, ma'am.
I don't know if you know, because this is the situation you've known for 20 years. I know, because I see this stuff all the time, that that's pretty rare and that you're pretty fortunate is all I'm trying to say. But, you know, you also, you know what you can spend and what you can't spend and what the times allow and what they don't and what the location is worth to you. That is unique. Just like what he wants to charge is uniquely his decision. What you want to pay is uniquely your decision. The only thing both of you have to do is respect the law, which in your state is that each of you have to give the other one 30 days notice. So you didn't give him 30 days notice about moving, right? And that's your complaint, Mr. Jack. How many days notice did you give her that you were raising the rent to what you're asking for, which is $1,500?
Well, I guess I gave that notice on January the 5th.
Well, that's debatable. You made an offer and you left it hanging for them. What you should have done is given them their 30-day notice. Do you hear me? Can you hear me, or are you just thinking about what you want to say? I need you to listen to what I'm telling you. What you should have done is on January 31st, told them, I'm giving you your notice. Or the second you walked in on January 1st, given them their notice. On December 30th, given them their 30-day notice, and then worked on negotiating. But you did not do that, and what's good for the goose is good for the gander. You can't all of a sudden look at them and say, oh, and by the way, you're going to owe me either the $1,275 or the $1,250 or the $1,500, whatever I feel like, 23 days from now. Because the first day that you followed up again was February 7th. So you don't get to charge for February whatever you feel like charging if nobody said yes to you before that. You guys were still in negotiations. So why should she pay for February anything other than the $800 that was her rent?
She offered nothing.
Yeah. And so what you did instead...
Last month's rent.
Right, but last month's rent how? Because I see your text. Your text to him is, take my security. What is your security, Ms. Laurie?
When I originally signed the first lease, I paid first month's rent $800 and last month's rent $800. He got none of that money. I guess none of that was ever transferred.
Can you prove that? Can you prove
no,
what
ma'am.
you just said? Right.
No.
I have your first lease. That's not what you did. All I need is for you to show me some proof. Do you have canceled checks or bank statements?
No, ma'am.
All that's no. So where are we? What we have, according to this lease, is that you had a $100 deposit, not a $600 deposit, not an $800 deposit. All you had was a $100 deposit. I find that based on what I have heard, you are not entitled to $1,500 for February, because the first time that everybody decides we're not doing business, we're not tangoing, is February 7th. And that is the day from what you should have done, Mr. Jack, is given them the 30-day notice well before that. Once you give them 30-day notice and you tell them your rent is going to go up effective 30 days from now, those are the rules you got to play by. Then you can say, hey, I want my $1,500. I told them 30 days ago. But you can't tell them that when the first time you come up with it is February 7th, because that's the first time they say, we're not going to stay. If you got lulled into a false sense of security, I'm sorry, but it behooved you on the end of January or at the end of December when you bought it to go ahead, if you wanted to preserve all your rights, to give them that 30-day notice. You've got to do it as much as they do. And you cannot skip paying February rent because you didn't give the full amount of notice that you're supposed to give. So he's right that he's entitled to rent for February because there is zero evidence that you paid rent for your last month, okay? The only evidence is that you didn't pay rent for your last month, that you paid a $100 deposit. So I am going to deduct $100 from the $800 that you should be paying in rent, and I am going to order rent paid to the plaintiff in the amount of $700. That is my verdict.
Well, a fascinating dispute with the plaintiff suing for $1,765. He's going to get $700 rent now from the defendants. Let's see what they feel about it, or defendant, because Lori, the case really ended up against you. How do you feel about this? What are you thinking?
I think he should get zero. That's how I feel.
Well, you may feel that way, but the judge feels differently, and she rules here. You have to pay rent for February. That's her decision. All right. You did move, right? You left the building?
Yes.
Okay, I know you were stymied for some evidence there, but you learned a lesson in court today. All right, let's talk to Jack. Jack, what do you think about the judge's verdict? You probably disagree, but tell me about it.
The facts are the facts, but I just wish I would have did what the judge said. I should have given them a 30-day notice. What it is what it is.
All right, sir, I hope things work out for you. You are going to get paid rent in February, and that's the judge's decision. Thank you very much. All right, Harvey, how do you feel about this one?
Okay, Doug, typically you have to give 30 days notice, and that is usually in the lease. But if it doesn't say it's in the lease, the reality is it's usually 30 days anyway, because most states say 30 days notice or else you lose your deposit.
My uncle used my car without my knowledge, and he got into an accident, and he wants me to claim it on my insurance. But I don't want my rates to go up since I wasn't driving. Can I force him to claim the damage on his insurance so I can get my car fixed?
All right, well, first of all, you can't even claim it on your insurance, because in order for your insurance to cover it, you have to have given that person permission to drive your car. If the person just took it, then there's no...
They're going to deny coverage.
Right.
They're going to say, no, we're not paying to fix that.
No, that's a theft.
And then where is he? Then he's got to sue his uncle.
Or
have his uncle make the claim on his own insurance.
On his own insurance, because he was driving. So he's 100% correct that the uncle should be making the claim. And if in fact the uncle says, well, that's not fair because I wasn't at fault. Well, that's not fair because you took his car.
Right.
You're supposed to return it the way you got it, and you're not supposed to take it without permission anyway.
Right.
So too bad for the uncle. And then if the uncle feels like the accident was the other person's fault, he could sue the other person and get it. But it's not nephew who has to go around chasing people he never met.
Right. I mean, the right thing to happen here is uncle makes the claim on his own insurance policy.
Or just pays it. If he doesn't have insurance, tough for him.
Well, apparently he does. Let's assume he does for a second. If he does, and he says, no, I'm not going to claim against my insurance company, and he won't give the insurance
then sue your uncle.
Over, you got to
sue your uncle.
Exactly.
And he's left you kind of no choice.
Right. That's where it might end up.